Good afternoon, everybody. This is my voice. My mouth doesn't seem to be tracking my voice accurately. Anyway, uh, maybe I should turn the sound on. Perhaps that would help. This is Mike Pelletier, and I'm bringing you an edition of the Unvarnished Truth from my home in the foothills of the Smoky Mountains in East Tennessee on Friday, February 10th, 2017. And the subject of my little diatribe today is, of course, the decision of the Ninth Circuit in State of Washington versus Trump, rendered yesterday a unanimous opinion which upheld the temporary restraining order against Trump's executive order. That initial restraining order came from a single federal district judge in the state of Washington, and who issued a nationwide restraining order on the basis of 15 minutes of oral argument before him, which I found extraordinary in and of itself. And I'm not, I am a lawyer, and in fact, I'm a constitutional lawyer. I've litigated a number of First Amendment cases on behalf of abortion protesters who get, criminally prosecuted for all kinds of things: trespass, harassment, you name it, obstruction, and I defend them. And so I know quite a bit about this area of the law. And I was, you could predict the Ninth Circuit decision. I mean, it's a commie court. Very high reversal rating. It's, based in San Francisco. 13,000 case backlog. Inefficient, despite the fact that they have 29 judges, 3 times more than any other federal circuit court. And it's extremely liberal, just like the federal district judge in Washington. So, I don't know if we're going to get it straightened out in the Supreme Court, because the balance there is 4-4, 4 conservatives, 4 liberals. So, if they go to the Supreme Court and the Supreme Court's votes 4-4, no action will be taken on the Ninth Circuit decision, and it will stand as the law of the case. And that is regrettable. But I hope, as Judge Andrew Napolitano has suggested, that there might be 1 or 2 members of the liberal wing of the court that could be persuaded to do the right thing here. So anyway, I just wanted to make a few comments about, really one very salient comment about the Ninth Circuit decision. I think it's salient in any event. The court devotes an entire section of their opinion to the issue of the reviewability of the executive order. It's section 4 of the opinion, runs for 5 pages, from pages 13 to 18. And the issue is whether, given the president's preeminence in foreign policy and national security, whether the courts have any role whatsoever in reviewing his decisions, or whether there must be absolute deference. And, I understand reasonable minds could differ about this issue in the abstract. But what really strikes me is that in these 5 pages, or nowhere in these 5 pages, and in fact, nowhere in the opinion, does the court cite the relevant operative statute, which the president himself quoted at several press conferences. It's Title 8 of the United States Code, Section 1182, subsection F. I mean, just listen to this. Whenever the president finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation and for such period as he deemed necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate, whenever detrimental to the interest of the United States, for such period as he may deem necessary, as he may deem to be appropriate. This is blanket authorization language, indicating complete deference to the President of the United States. And it is nowhere mentioned, despite the fact that Trump quoted it at press conferences. A layman. This court, in reaching this conclusion that it has the right to review the president's actions, doesn't mention this statute. This is absurd. The question remains, however, okay, let's look at that statute, and let's assume further that the court has some right to review the president's conduct under that statute. You know, the idiocy of the Ninth Circuit, they found that there were two constitutional provisions that the executive order might be violating and that they could review, without mentioning the statute, of course, which indicates non-reviewability. I mean, it's incredible to me that they don't even mention Section 1182, but I've already said that. They cite the Fifth Amendment Due Process Clause, which attaches to some, aliens and immigrants. They have a right to due process. When you're operating, and due process means, basically, it's a procedural constitutional provision, which means that before any adverse action is taken against a person, they should have an opportunity to be heard. Okay, in general, I agree with that. But when the subject matter is terrorism and national security, do you want to give a class of aliens and that you suspect might be, some of whom might be terrorists, an opportunity to be heard before a rule is entered barring them from entry? I don't think so, because all of the terrorists will be posing as refugees and try to get entry immediately during the hearing process before the rule is imposed. No, you have to impose the rule. So, it is just idiotic to think that the Constitution requires that notice be given to terrorists before they are excluded, or potential terrorists. It's just insane and typical of liberal thinking. The second constitutional provision, the court says, that the executive order might violate is the First Amendment, freedom from religion. The court basically says this might be a Muslim ban. And I'm not going to get into whether it is or it isn't a Muslim ban. Most of the world's Muslims are not excluded, only Muslims for these 7 countries, which represent about 15% of the world's Muslim population. But I guess what I want to say is, what's wrong with a Muslim ban? Everybody's assuming if it is a Muslim ban, or even the government is arguing it's not a Muslim ban, because they know, or they think, that if they admit that it's a Muslim ban, it's unconstitutional. How is a Muslim ban unconstitutional? And this is the idiocy that plagues most of the country, most of whom supported Trump, about liberals and liberal courts and liberal legislatures and liberal executives. It's the blind idiocy. We understand that not all Muslims are terrorists, but all terrorists are Muslims. So what's wrong? What would be wrong with a religious ban? Until we can get our vetting processes in order. No Muslims can come in because it's only Muslims who tend to be crazy radical terrorists. And that's a fact. The same idiocy that leads to this court's decision is the idiocy that leads to white grandmothers being strip searched at airports. It's just dumb. Why shouldn't you profile? All terrorists tend to be young, male Arabs, Muslims. That's not my fault. Those are the facts. What is wrong with a Muslim ban? So there's no. Even if this is religiously motivated, I don't see a First Amendment violation. Everyone assumes there is. But I take you back to the initial observation here. This decision is utterly bankrupt. 29 pages of fluff that doesn't even mention the statute that gives the president unreviewable authority to impose this ban. Not even mentioned. It's absurd. And I certainly hope Trump takes this to the Supreme Court. I hope he appears in the courtroom when the case is argued. And I hope Jeff Sessions, is the Attorney General of the United States, argues the case for the Justice Department. We need to make the court aware of just how important this is. And, this is symptomatic of a broader problem. If this is affirmed by the Supreme Court, there will be hell to pay, because it underscores that there is no common sense among liberals. They are going to civil rights us until we are dead. And, I'd rather be dead. I'd rather be alive than be accused of discrimination. I'd rather be alive. So in any event, that's all from here. That's my review of the Ninth Circuit decision. And that's the Unvarnished Truth for Friday, February 10th, 2017. Have a good day.